Afternoon. Let's go on the record, please. I'm Charlotte Mitchell, Chair of the North Carolina Utilities Commission. With me this afternoon are Commissioner Clodfelter to my left and Commissioner Duffley on the screen. I now call for hearing docket number EMP-119 sub 0 and 1, which is the application of Macadamia Solar LLC for a certificate of public convenience and necessity to construct a 484 megawatt solar photovoltaic generating facility in Washington County, North Carolina, as well as a transmission line to connect that facility to the grid. All right, it's the Commission's understanding that the parties today do not intend to cross-examine the witnesses of the other parties and that the witnesses are being presented today for the limited purpose of answering the questions posed by the Commission in its September 2nd, 2022 order accepting supplemental testimony and providing questions to be answered at hearings. All right, if that is true and there are no objections from the parties, I'm not seeing objections at this point, the Commission will consolidate the proceedings in docket numbers EMP-119 subs 0 and 1, EMP-110 sub 0, and EMP-111 sub 0, solely for the purpose of receiving testimony on the questions set forth in the Commission's September 2nd, 2022 order. Therefore, the Commission now calls for hearing in addition to this docket, EMP-119 subs 0 and 1, dockets number EMP-110 sub 0 and EMP-111 sub 0. All right, with that, I'm going to call on parties to make appearances for the record, beginning with the applicant.
Good afternoon, Chair Mitchell, Commissioner Clodfelter, Commissioner Duffley, Ben Snowden with Fox Rothschild for the applicants, Macadamia Solar, Sweetleaf Solar, and Sumac Solar. And I have with me today my associate Jack Taggart, also of Fox Rothschild, here on behalf of the applicant.
All right, good afternoon, Mr. Snowden, Mr. Taggart, public staff.
Robert Josie with public staff on behalf of the using and consuming public. I'm here with Nadia Allure and Zeke Creech.
All right, Mr. Josie, and I assume that the three of you are making appearances in all dockets?
Yes.
Okay, well, the record will so reflect, so you are. Okay, all right. So we are doing things a little differently today than we typically do, but we will proceed anyway. All right, it's the plan to hear from the witnesses today in response to the questions submitted or issued by the Commission in its September 2nd order. A copy of the transcript addressing these questions will be placed in all three dockets. So that is the plan. So the transcript from today's proceeding will be placed in the dockets EMP-119, EMP-110, and EMP-111. The Commission will issue a subsequent order in each of their respective dockets, accepting into the record the testimony, the pre-filed testimony and exhibits of the parties' witnesses in each of those dockets. All right, let's go ahead and get started. Mr. Snowden, why don't you go ahead and call your witness or witnesses?
Thank you, Chair Mitchell. And if I may, I'd like to call our witnesses as a panel.
You may.
Okay, thank you. Right.
Assuming no objection. Okay, go ahead.
Okay, thank you. The applicant calls Kara Price, Donna Robichaud, and Amanda Mack to the stand.
All right, good afternoon. I'm going to go ahead and swear you all in. Raise right hands, if you will. Left hand on the Bible. You swear testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right, Mr. Snowden.
Thank you. Ms. Price, I will start with you. Could you please state your full name and business address?
Yes, the name is Kara Price. Business address is GeneX Solar. Current address is 1000 North Carolina Music Factory Boulevard, Suite C3, Charlotte, North Carolina, 28206. That is a change from the address that was on the original testimony.
And Ms. Price, who is your employer and in what capacity do you serve them?
Yes, my employer is GeneX Solar, LLC. At the time of the submitted testimony, I was Senior Vice President of Permitting and Development. Current title is Senior Vice President of Strategic Engagement.
Thank you, Ms. Price. Ms. Mack, I'll move on to you if it's okay. Ms. Mack, could you please state your full name and business address for the record?
Yes, Amanda Mack, 3600 American Boulevard West, Suite 400, Bloomington, Minnesota, 55431.
And Ms. Mack, could you please specify who your employer is and in what capacity you serve?
Yes, EDF Renewables, Project Manager of Development.
And Ms. Mack, just to be clear, you provided testimony in EMP 110 and 111, but not in 119. Is that right?
That is correct.
Okay, thank you. All right, Ms. Robichaud, move on to you. Ms. Robichaud, could you please state your full name and business address for the record?
Donna Robichaud. The business address for GeneX Solar is 100 NC Music Factory Boulevard, Suite C3, Charlotte, North Carolina, 28206.
And Ms. Robichaud, who is your employer and in what capacity do you serve?
My employer is QF Holding Corp., formerly QF Solutions LLC. QF Solutions has been under contract to provide consulting services to GeneX Solar since 2013. I serve as the Senior Vice President of Development Strategy for GeneX Solar.
Thank you, Ms. Robichaud. Chair Mitchell, the applicant would like to provide some additional direct testimony from Ms. Robichaud relating to the issues that were included in the commission's order from Friday. And public staff says they don't object. Is that permissible?
You may proceed, and public staff, I'll allow you the opportunity to cross-examine the witnesses.
Thank you. Ms. Robichaud, I would like to ask you a few additional questions that are related to the supplemental testimony that the public staff witnesses, Jay Lucas and Evan Lawrence, provided that was filed on August 30 and accepted by the commission on September 2nd. Is that okay?
Yes.
Okay. And this also relates to the directly to the questions that were raised in the commission's order from Friday. Is that your understanding?
Yes.
Okay. Did you review the public staff's testimony from last week?
Yes.
Okay. In their testimony, Mr. Lucas and Mr. Lawrence discussed the costs that Macadamia Solar proposed to pay to expedite the work under the ASOA. Is that your understanding?
Yes, it is.
Okay. And why did Macadamia want to expedite that work?
Macadamia wanted to bring the project in a year earlier for the benefit of Macadamia and the two other projects because of the ITC cliff was one of them that it was going to, at that time, had not been extended. Two, landowner agreements. We have options to extend leases, purchase options, and many of these agreements were executed in 2017. So they're over 5 years old now. So we had to continue to maintain our relationship with our landowners on our agreements, but we're running out of some of the pre-programmed extensions. And we might have to renegotiate POI, option agreements, things like that. So we considered that a project risk. The other project risk was zoning. Again, this is a very old project. We received zoning for sumac and macadamia several years ago. We've been getting annual extensions. The concern is that ordinances could change and the counties could say, well, no, I'm not going to do an automatic extension. You'll have to reapply. Sometimes when they redo zoning ordinances, they'll limit sizes, they will add height restrictions. And so with not knowing what would come up, we considered that a risk. General inflation was a risk. The EMP that we would hopefully receive will retire in 3 years in 2025 before the efforts to Greenville update is completed. And the last thing is related to marketability, which I could cover under confidentiality if you would like to proceed.
So Ms. Robichaud, is it your understanding that the Inflation Reduction Act extended the investment tax credit past 2025, so that ITC cliff was not after the extension, that ITC cliff was not a factor in deciding to expedite the projects?
It was not the main driving factor.
Okay, so even after that ITC was extended, there were still a lot of reasons to want to expedite the DEP upgrade?
Yes, there is.
Okay. And to be clear, GeneX had sought an ASOA, or I'm sorry, Macadamia had sought an Affected System Operating Agreement, or ASOA,
with Duke, under which it would not receive reimbursement for the costs of expediting that upgrade?
That is correct.
Okay. What do you understand about how Duke calculated the costs to expedite that upgrade?
So Duke happened to coincidentally have a reliability project that included a double circuit line, Greenville to Aurora, Greenville to Everett's. And they priced that project out at $19.8 million. So the portion we affected was much smaller than the total project, but they would not bifurcate the construction and the engineering of two lines that happen to be on the same towers. So they said, I will need to bring forward the entire reliability project, with the exception of the engineering. They were going to complete the engineering starting in 2023, but they would bring forward a year the purchase and construction of the remaining reliability upgrade. So they took the 19.8 million reliability project, subtracted from that the 1.4 million for the engineering and construction, or the engineering and permitting that they would have done anyways, and the leftover was 18.4 million. They took that 18.4 million and said, what is my weighted average cost of funds if I had to borrow money to perform the project a year earlier? And so they took basically their cost of capital using their WACC, which included debt and equity and the percentages of that, and applied that and compounded monthly payments to come up with the 1.615 million expediting cost. It is solely financial. It's not overtime or any third-party vendor increases.
Thank you, Ms. Robichaud. Are you aware of whether there is a standard way to calculate these sort of expediting costs under FERC jurisdictional agreements?
Not the financing cost. Both our attorney that was helping us negotiate it and FERC's attorney tried to find an example to follow, and we could not find one. So it's a novel approach, a little bit simplified, but it would be the first that we know of.
Thank you, Ms. Robichaud. And it's your understanding that if Duke were to file an ASOA with FERC for approval that included these expediting costs, FERC would review how Duke calculated the expediting costs. Is that right?
Yes, they would. We had 2 meetings with FERC prior to filing it because we wanted to not seek reimbursement. So we went over the cost and FERC asked for detail. Then we had a second meeting, and the second meeting included us and Duke went over the detail that they presented in the North Carolina docket. FERC at that time would not respond. They keep pretty quiet because of the Edgecombe rehearing request and other things in the FERC docket. So you couldn't tell a read exactly when you talked.
So, Ms. Robichaud, in your view, is there a question as to whether FERC would approve of or accept Duke's calculations of the expediting costs?
Our general thought was it was really simplified and it was novel. So we did expect questions. We expected perhaps a deficiency that would modify it another way, or, there are other ways to figure out expediting costs. So we did expect that they would issue a deficiency.
And Ms. Robichaud, what is your understanding of what would happen process-wise if FERC disapproved of or had questions about Duke's calculations of costs?
It would definitely extend the deadline. Our goal was to submit the ASOA by September 1st prior to this hearing to FERC. And what would have happened would have been 60 days later. By November 1st, they would accept, deny, or issue a deficiency. If they issued a deficiency, there would be 30 additional days by December 1st where Duke would respond to that deficiency. And then FERC would have another 60 days to react to that response. So that puts us out to February 1st of 2023 at the earliest, assuming we would have filed at September 1st.
Thank you. So is it fair to say that even if FERC accepted an ASOA that waived macadamia's right to reimbursement, it still might not end up issuing a decision accepting an ASOA until sometime next year if it had issues with the way that Duke calculated the expediting costs?
Yes, I would agree.
Thank you. And could you please explain why Macadamia Solar withdrew its request to expedite the ASOA despite the factors that you had mentioned previously?
Yes, there are, developing a project is all about managing the risks. So there is some huge risks coming for sweet leaf and macadamia in the manner of putting security down for the interconnection service agreements. We should soon have an ISA tendered to us for Sweet Leaf Solar. And Sweet Leaf Solar, when they sign their ISA, will probably have to fund up to $80 million of security. And then 2-3 months later, Macadamia is going to have to fund up to $70 million worth of security. So trying to get financing without a CPCN is a huge risk. So if we go to a bank or go to a loan and say we don't have a permit to build, their next question would be, well, why would I give you money to sign an ISA? So that's a huge risk. It was bigger than the risks that we had we previously stated. So we chose to forego our expediting so we could keep our CPCN on track.
Thank you, Ms. Robichaud. I'd like to clarify one other fact too. So is it the case though that it is now not going to be macadamia, but sumac solar that will be seeking an ASOA with FERC that does not call for expediting?
Correct. Sumac all along was designated the person that was, or the company that was going to sign the ASOA. But with the expediting cost of 1.6 million, it was too much financially for Sumac to handle. So Macadamia was going to step in, being the largest project, 484 megawatts. It could easily accommodate those costs. Well, not easily, but better than Sumac, which was an 80 megawatt project. So now when we pulled the 1.6 out of it, the ASOA, and it was left to be what we believe is going to be $150,000, it was in a size that Sumac could handle. And so Sumac went and took back their responsibility of being the one that signs the ASOA.
Thank you. Ms. Robichaud, did you see the commission's order on September 3rd that directed the applicant to answer certain questions related to expediting costs?
Yes, I did.
Okay. Although those questions may be mooted by Macadamia's decision not to pursue expediting, I'd like you to answer those questions as best you can. Is that all right?
Yes.
Thank you. So the first question posed by the commission is, under what circumstances will the $1.6 million in affected system costs outlined in your testimony increase, decrease, or otherwise change? Can you answer that question?
Limited. It now will be zero, so it won't change. But the financing cost was based on an estimate of the construction and procurement of the upgrade. And the engineering for that and the procurement for that has not yet been done. So I sort of suspect that after 2023 into 2024, Duke would have a better picture of what the cost of that upgrade was going to be. And they would reapply different, if it changed, they could have applied a different basis besides the 18.4. They also might have a rate case before then, and their weighted average cost of capital could change. So there are some factors that I see could change, and possibly input from FERC if FERC wanted some changes in the expediting cost.
The next question is this: how confident are the applicants that the $1.6 million figure is the final amount in the affected system costs? And I think you've answered that, but if you don't mind just answering that directly.
I think it's going to be off by at least a little bit, whether it's 1%, 20%, I don't know. But, you know, I don't see it nailing it dead on, but I think it's going to be in the range.
Thank you. And if you can answer this, if the affected system costs were to change, do you have any idea what the magnitude of that change might be?
So the affected system cost right now is that's assigned to SUMAC is $150,000. And that covers the cost of a higher rated capacity line for the Everett's to Greenville section. So, you know, if they do their final engineering and the base cost is off a little bit, it's a differential between the two. I thought maybe if there was some escalation, but again, it's a difference between the smaller and the larger conduit size. So it could change. Again, they may not nail it, but I think it's definitely within the range of what they said.
Thank you. And this is going to go back to the ASOA that you all were seeking to enter into. Had you proceeded with the ASOA requiring expediting but waiving reimbursement, and the amount of the expediting costs had exceeded $1.6 million, who do you anticipate would have paid that extra money?
Macadamia Solar.
Thank you. Chair Mitchell, Ms. Robichaud and Ms. Price and Ms. Mack are now available for commissioner questions. Okay. Oh, sorry. For cross-examination and commissioner
ahead.
questions.
Just a couple. You stated that the most recent estimate for the affected system upgrade cost was $150,000, and it had previously been $350,000 after DEP had determined that it was going to rebuild the line. Do you know why it changed from $350,000 to $150,000?
I do not.
And you just stated that under the ASOA, that Macadamia was going to sign with DEP that did not provide for reimbursement, that Macadamia would have been subject to would have repaid any amount of money had the estimate changed from the $1.6 million. But under current FERC policy, DEP ratepayers would normally be subject to that cost had FERC disallowed the ASOA without the reimbursement, correct?
FERC's normal policy right now is not to require reimbursement, correct?
No further questions.
All right, you may redirect if any.
No redirect. Thank you.
All right, Commissioner Clodfelter.
First of all, congratulations on your office relocation to the Music Factory.
Thank you.
Great
It's a
place.
fun place.
It's a great place. Just is a lot of very interesting information, but just to be sure, I get the core absolutely clear in my head. Nobody now is going to be asking for an expediting of the actual construction of the project.
Correct.
That issue is gone.
Correct.
Sumac's not asking for it.
SUMAC is not.
Neither is Sweetleaf nor Macadamia.
Neither Sweetleaf or
That's all I've got.
Macadamia.
Thank you.
Okay, just a few questions for you. You discussed in your testimony the process you all went through in sitting down with the FERC and walking through the method used to develop the expedite fee. And you referenced a FERC attorney or FERC's attorney. Do you remember the name of that attorney?
Our FERC attorney.
Oh, it was your FERC attorney. It
Yeah.
wasn't an employee of the Federal Energy Regulatory Commission.
No, our
Okay.
attorney is,
Okay, then you don't have to answer that question. You also discussed developing the method with Duke. Do you know the name of the Duke employee that you all worked with?
the gentleman, we met with him. I just don't remember his name.
Was he in which,
Rates. He was in a rates division.
okay,
So we had a team of people we met with, Ann Warren, Christina, transmission folks, rate folks, and project folks. And so there's a group of 5 or 6 people. We went through a method that they came up with. I proposed some alternate methods. All the methods we came up with were a little bit too simplified and had holes. So we just opted to stay with what we had. The different methods were pretty close in the final outcome anyways. And so they had amongst themselves in the rate department discussed what the appropriate way was. And we had several people weigh in on from Duke saying that's probably the way they do it. And that's how that's how we ended up settling on before we went to our FERC conferences.
okay. Is it your understanding and was it your team's understanding that the costs associated with expediting the construction of the facility would flow through the OAT in the same way that the affected system costs would flow through the OAT?
Yes,
Okay. And was that Duke's understanding as well?
yes.
Okay. Do you know pursuant to what term of the OAT those costs would be governed? If you don't, that's okay. I'm just,
I do not.
okay, that not a problem. I just curious if you knew off the top of your head. Okay. So as I understand it, the facility is to be, so let me ask the question this way. My understanding is that Duke's plan to construct the Everett-Greenville line is to occur in 2027, or at least be placed in service by 2027. Do I understand that correctly?
Actually, they told us now it was 2026, but they gave themselves a 6-month buffer. And in the affected system study agreement, they called it June 1st, 2027. But that's only if unforeseen circumstances arise, would it stretch into 2027?
Okay, so let's assume that Duke is able to construct this line in 2026 without having to move into its buffer. That time frame is consistent with the needs of the projects we're discussing today, macadamia, sumac, and sweet leaf.
It will work with all 3 projects, yes.
So the projects at this point in time don't see a need to request expediting of Duke's work.
Now, we have risk we will mitigate in order to make the 2026 work.
Okay, okay. All right, let me check in with Commissioner Duffley. Questions, Commissioner Duffley?
No questions.
Okay. Questions on commission's question? Oh, go ahead.
Be sure there's nothing under this rock. There shouldn't be, but let me just ask it. So the cost of the reconductoring are all attributable to the Greenville Everett's line, none to the Greenville Aurora line. They'll be on the same structures, right?
Correct.
Okay. As I say, there shouldn't be any cost, but I just wanted to be sure.
And Ms. Robichaud, I'm going to ask you this question. And if you don't know the answer, that's totally fine. What's your understanding of why Duke moved this work from an upgrade project to a reliability project?
Well, technically, they were working on the reliability project, which is much bigger. You got the Greenville to Aurora line, which is, I don't know, 12 spans, must be like 12, 50 miles or something like that. And our little section, which was only 1.8 miles. And so I think they were probably focused more on the larger piece. But because it was on the same conduit, they didn't focus as much on the smaller Everett's to Greenville. So I think once they finished their reliability planning, they realized they were addressing the same structures, and they ended up saying ours is part of the reliability plan and no longer pursued it.
Okay. And when you say same structures, do you mean tower replacement and wires replacement?
Right, so they have common towers. So Duke is planning to build an adjacent double circuited line to the current line, of which our Everett's to Greenville 1.87 will be on that. And then the other very longer line will also be on it.
Okay, so Duke is going to build, one last question for you. Duke's going to build a new double circuited line adjacent to the existing line, and will the existing line then be taken out of service once the new double circuit's in service?
That's my understanding.
Okay, all in the same transmission right of way?
They have to acquire new right of way. They don't have enough right of way. So, but it's going to be adjacent in parallel to the existing right of way for the upgrade.
Okay, but your understanding is outside of right of way.
Correct.
Okay, okay. Do you know whether Duke will seek a CECPC in for this project?
I do not.
Okay, thanks for your responses. Anything else? Duffley? Okay, questions on commission's questions. We'll start with the public staff and then Mr. Snowden.
Just have two. You mentioned that there were 2 meetings with FERC staff.
Correct.
Can you say why there were 2?
Initially, Duke was reluctant to negotiate another agreement that could be rejected by FERC. So they thought about it and talked amongst themselves and came back and said, if you talk to FERC and try to get a read from them, we'll consider it. So we came up with a plan where we talked to FERC and we told them why we wanted it. FERC sort of gave us an outline to follow on the data they would want and information they would want. And then we didn't have very good information about the expediting cost. So we came back for a second meeting. This time it was with Duke. And we explained the expediting cost and sort of went through the project. So I think we were waiting to see if FERC slammed the door. They did not. And so we were planning to proceed based on their guidance to us.
Okay, and FERC's interest in the expedited construction cost fee, I mean, is that, as you said there earlier, there's no other facility to your knowledge that's asked for this expedited construction?
We had found some cases, but they weren't for financing costs. They were overtime, additional equipment procurement cost, sort of things from third party, but not cost of capital type of expediting cost.
Thank you. Just one or two. Ms. Robichaud, just to be clear, even with the updated timelines for the DEP upgrade that you guys received and you referenced a few minutes ago, withdrawing the request to expedite does increase the costs and risks for the project. Is that right?
Yes, it does.
Okay, but it's just that you all are able to mitigate those risks and costs and live with them rather than increase the risk for the CPCN. Is that right?
Correct.
Okay, thank you. Those are all the questions I have.
Ms. Robichaud, we have one more question for you, then we'll go through the round again. You just mentioned in your research, y'all had identified several other projects that involved expedite fees. Were those Duke projects?
No.
They were, which utilities were they?
One was in CERC, and I don't remember the
Okay,
other one.
but not DEC or DEP?
No.
Okay, all right. Questions
I have one question.
on that question?
On that question,
Okay.
yes, indeed. So, Ms. Robichaud, is it your understanding that the FERC standard, the OAT, the pro forma interconnection agreements and procedures specifically provide for expediting costs. Is that right?
The OAT does provide for expediting cost, and it says that if we fund it, we would get transmission credits back.
Okay. It's just that there's not a standard methodology for calculating costs that's in the OAT anywhere. Is that right?
Correct.
Okay. Thank you.
All right. With that, I believe we have come to the end of cross-examination and examination of these witnesses, unless I'm missing something. All right, you all may step down. Thank you very much for your testimony today. All right, any other additional witnesses?
Chairman, do we have Robert Turnbull, who is specific to EMP 119 sub 1, the transmission line case? We're certainly happy to present his testimony here, but my understanding is that if we're in a consolidated hearing, then it may be better for the commission to take his testimony outside of this
Right,
hearing.
and you would be correct on that last point. So we will not hear from him today, but we will address his testimony by later order of the commission.
Okay, thank you. So we have no other witnesses.
Okay, public staff, you may call your witnesses.
Public staff calls Jay Lucas and Evan Lawrence.
All right, gentlemen. Place left hand on the Bible, raise right hands. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I'll ask you a couple qualifying questions. Mr. Lucas, I'll start with you. Could you state your name, business address, and position with public staff?
My name is Jay Lucas at 430 North Salisbury Street, Raleigh, North Carolina, and I am the section manager for operations and planning in the public staff's energy division.
And Mr. Lawrence, can you answer the same questions?
My name is Evan Lawrence. My business address is 430 North Salisbury Street. I'm an engineer in the operations and planning division section of the energy division.
Chair, this panel is open for commission questions.
All right, so just to be clear for the record, it's my understanding that the applicant has no cross-examination for these witnesses. So we will start with questions by the commissioners. And let me check in with, well, Commissioner Cladfelter, do you have questions for the witnesses? Yeah. Go ahead.
Gentlemen, in no particular order, some of these questions right now may be of academic interest given the change in circumstances, but since you put them in your supplemental testimony, we're going to ask you about them, if that's all right. One of the things that was in the supplemental testimony was the contention that PJM had the ability to make certain upgrades within, I assume, the DENC system or somewhere else in PJM. I don't know exactly where because that's not identified, that would obviate the need for Duke Progress to incur costs for any affected system upgrades. And I wanted to hear more about that. What were you referring to? Say more about what PJM, what you believe PJM could have done to avoid these affected system upgrades, or to avoid, they're not affected system upgrades anymore. They're the reconductoring of the Everett's Greenville and Everett's Aurora lines. What could PJM have done to avoid that?
It wasn't necessarily to avoid those two upgrades, those two transmission lines. The public staff had a discussion with Dominion staff, and I believe PJM staff was there a year and a half ago, something like that. And they discussed the possibility of a new 500 kV line in Southern Virginia to alleviate the congestion in DENC and possibly other points in Southern Virginia. We asked Dominion that specific question on September 2nd, and they responded that they had considered a new 500 kV line from the Everett substation up into Suffolk, Virginia. That was to help resolve the reliability problems, but they decided that that line would not be cost effective, and would not have been cost effective in resolving the deficiencies. Let me put it that way.
But that would have been, as you describe it, and make sure my understanding of it's correct, that would have been a major new project, and it would
Yes.
have addressed reliability issues that go far beyond anything that might have been occasioned by interconnecting these three projects.
Yeah, they've gone way beyond these three projects.
So that project was really not specifically associated with the consequences of interconnecting these three projects to DENC's grid.
That's correct.
Okay, well, thank you for that. I appreciate that clarification. What kind of investigation did the public staff do or has done into the circumstances that led Progress to reclassify the Everett's Greenville reconductoring as a reliability upgrade?
We found out about the upgrade on DEP's side to resolve problems with the line due to age and condition. We found out it was after DEP released its affected system study, its latest one on June 8th. We asked some questions about the incremental upgrade necessary in comparison to DEP's upgrade due to age and condition. We also asked DEP some questions on September 2nd after getting the commission's order. If I can summarize this for you, we had that correspondence and we can provide it as a late filed exhibit, but they did not want to present it to the NCTPC at this time because they just weren't ready to. They want to get the affected system operating agreement in place and approved by FERC. So it's all preliminary. We don't have a lot of information right now on that line other than that.
Well, unless there's some objection, just out of curiosity's sake, I'd be interested in the late filed exhibit unless there's some objection to that.
No objection.
Okay. What I want to understand is the scope of the proposed reliability project as compared to what was originally identified as being an upgrade caused by or occasioned by the interconnection of these three projects. Has the scope, how does the scope of those two compare? When you first learned about this, it was going to be an affected system upgrade. Has the scope of the project changed now that it's become a reliability project? And if so, how?
I don't believe the scope has changed for that reliability project, but first came the plan for the interconnection. And then after DEP evaluated the line, they made the decision to upgrade that line based on its age and condition. At this time, I can't separate what would have been occurring at DEP without interconnection of these three facilities.
Well, would it be fair then, from what you do know, would it be fair to say that the filing of the applications for interconnection and the consequent need for the affected system study is what triggered Duke to realize that it had an end-of-life problem on these lines?
That's what I've gathered, but I can't testify exactly what DEP had done in the absence of the three facilities.
Doesn't sound like you have much more information than what you got from Duke in the recent exchange of correspondence. Is that accurate?
No, not anything other than what I've already told you.
Okay. I'll leave you alone then. Thank you.
All right, Mr. Lucas. The 500 kV line that Dominion was planning that you discussed early in your testimony or early in your responses to Commissioner Clodfelter's questions, do you know, was that considered a supplemental project by DENC for purposes of the buckets of projects that PJM,
I'm not sure what you mean by supplemental project.
like a local, as opposed to a project that would move through the RTEP, or
It was
this is a
large
local?
scale. It was, I would say it's beyond local project. It was 500 kV project that would have moved a whole lot of energy out of DENC and up into Virginia.
So would it have been considered as part of the PJM RTEP?
I can only guess so, just by the size of the line. I don't have
Okay.
any definitive information.
That's all right. Okay. Okay. All right. you also discussed upgrade due to age and condition. So my understanding of what happened in this case is DEP, at least as I understand your testimony, DEP performed a series of affected system studies associated with these interconnection requests. And between the first revision and the second revision, moved the upgrades identified in these studies from upgrades associated with the interconnection to upgrades for reliability purposes. Do I understand that correctly?
Well, it became both. It was an upgrade due to age and condition, and some increase.
The
some
incremental portion would be attributable to
to
the,
the 3 facilities. Yes.
okay, all right, all right. But I understand that correctly. I mean, that's.
Yes, yeah,
Okay,
between, I guess, called the second and the third affected system study.
Okay.
DEP decided to do the upgrade.
was it you've kind of danced around this with Commissioner Clodfelter, but was it a surprise to the public staff that at least a portion of this project or this facility was identified as needing to be replaced due to age and condition?
Yes, it was a surprise. We only learned about it right after the release of the latest affected system study on June 8th.
So how much visibility does the public staff have in general about transmission assets and those that are nearing that point in time where they need to be replaced due to age and condition?
We find out some of them by looking through the NCTPC website. There's no direct notification by Duke Energy. They don't need a certificate to do these. We primarily get involved during cost recovery during a general rate
Yeah.
case.
So is it your understanding that this Greenville to Aurora line would not need a CECPCN?
You mean Greenville to Everett's?
Well,
Or
Is-
either one.
so how, okay, let's start at the beginning then. So the project goes from Greenville to Everett's and Greenville to Aurora as a segment of the larger Greenville to Everett's line?
I do not believe they would need a certificate.
Okay, but just help me understand the components of the project. It's a Greenville to Everett's line,
Yes.
and then a segment of that line is Greenville to Aurora.
I had not heard about the Aurora part at all until today.
Okay, all right, well, so, but the Greenville to Everett's portion would not need a CECPCN.
That's correct.
Okay, and so did you hear Ms. Robichaud's testimony that it would be, that she understood the project to be outside the existing right-of-way?
I just learned that today, but it could be in the area. If it's an adjacent easement, it still would not need a certificate.
It wouldn't need a certificate.
It
And
would
so,
not.
and so we're doing a double circuiting. We're basically building a whole new line, as I understood Ms. Robichaud's testimony, new towers, double circuit, taking the old towers and the old line out of service, and you still wouldn't need a CECPCN.
That's correct.
Okay. Okay. And I understand, make sure I understand your testimony correctly. You all, the public staff doesn't learn about, let me say it this way, doesn't always learn about facilities that need to be replaced as a result of age and condition until situations like this, there's an interconnection request that triggers study of these facilities, or
Yeah.
they appear on the NCT. Let me ask the question again so I'm clear. How much visibility, how much foresight does the public staff have about facilities on the transmission facilities that need to be replaced due to age and condition?
We would only see that by going to the NCTPC website. That's the only way we find out about it. And this one came up because they were an affected system study. That's the only way we found out this early for this particular line.
So it wasn't yet on the NCTPC?
It's not yet.
Okay, but but presumably it would be at some point.
Yes.
Okay. Okay, got it. And how much foresight or how much advance notice does appearance on the NCTPC give the public staff?
That would give us probably a couple of years.
Okay,
Notice
not
plus-
10 years?
There's forward-looking plans where some of this type of work could be done, but I couldn't tell you specifically.
Okay. Does the public staff agree with the applicant's contention that expedite costs would flow through the OAT in the same manner that affected system costs would flow through the OAT?
I can't address that right now. We would be concerned about these affected system costs being placed on the using and consuming public.
Okay.
So we could oppose them.
Okay, I got, you answered my question. All right. In the discussions, this is for either of y'all, in discussions that you all, the public staff has had either with PJM or with Duke Energy Progress, what have you learned about PJM's obligation to pick the least cost affected system upgrade that occurs on the DEP side?
I don't have any knowledge about PGM being required to do any least cost.
So is PJM obligated to identify a least cost solution on the affected system cost side? Or is DEP obligated to identify a least cost solution?
I don't know about PJM, but normal practices during the public staff's review during a general rate case, we would look at the prudency of those expenses.
You would look at the prudency of both Dominions.
Of DEP's cost to do the affected system upgrades. That'd be part of the general rate case.
Okay. Have you ever participated in the review, in the audit of affected system upgrade costs incurred by DEP?
No audit other than us reviewing the affected system studies.
Okay. Okay. I'm trying to determine, have you all had to review any of those costs yet?
They have not come up in a general rate case yet.
Okay.
These have all happened fairly recently, and I'm not sure that there have been any substantial ones that have been within a rate case.
Okay.
And my understanding of the process from PJM side, they let their affected system know that there is a potential for problems, and then it's up to that affected system to actually study it and determine whether the best course of action and whether the costs or how the upgrade or how the reliability concern, if there is one and if it needs to be addressed.
Okay. So, Mr. Lawrence, do I understand your testimony to be that PJM would rely on the affected system to identify the upgrade necessary to meet its system needs, and PJMs were out of the process?
That's correct.
Okay. Have you, as a public staff, heard from any other merchant facilities or proposed merchant facilities about a need to expedite construction or expedite any other costs associated with costs or work associated
This is
with?
the first time we've ever seen expedited costs.
Did the public staff participate in the meeting with the FERC and Duke?
No.
Has the public staff had any discussions with the FERC about the expedited costs?
No.
Okay. All right. Commissioner Duffley.
So just a couple of questions. Going back to the end of life, are you aware, does Duke have metrics for determining end of life? Like X number of years? How do they determine that a line has reached its end of life? And do they have that written down somewhere?
Yeah, they do have procedures. This line's held up by 2 wooden poles, and they have a program where they periodically drill holes into the power pole and see what's going on, and they put a little tag on it. When they find that it's still sound, to schedule the next time to come around.
Okay, and then going to Chair Mitchell's questions about PJM and what they're doing on their system can potentially minimize the affected system upgrades on DEP's system. Do you know, does Duke get involved with making suggestions or changes that you're aware of?
Yeah, I'm not aware of any communications like that.
Okay, thank you. I don't have anything further.
All right, we will take questions on commissioners' questions. Mr. Snowden.
Thank you, Chair Mitchell. Mr. Lucas, I just had a couple of questions regarding, to follow up on the commissioner's questions regarding the scope of the reliability project. Did you hear Ms. Robichaud's testimony from earlier that the reliability project that DEP is now contemplating involves replacing additional line segments beyond the Greenville, beyond the Everett's-Greenville segment that was called out in the original affected system studies?
I did not know that it involved additional line segments other than the Everett-Greenville line.
Okay, so you had not previously heard about the Greenville to Aurora line also being part of that reliability upgrade?
I had not heard that.
Okay, but you don't have any reason to disagree with Mrs. Robichaud's testimony on that, do you?
No.
Okay. Those are all the questions I have. Thank you.
All right. Public staff.
Just a few. Mr. Lucas, you were talking or explaining to the chair on her question about whether or not the public staff had reviewed any affected systems upgrade cost, and you had said no, correct?
That's correct.
Yes. To your knowledge, it was about 2020 when the public staff realized that affected systems upgrade costs was an issue.
Yeah, we did not realize affected systems were a problem until May of 2020.
And to your knowledge, the only facility to have a CPCN issued that has affected systems cost up until this point is Edgecombe Solar.
That's correct.
Okay. And so the public staff would review those affected systems upgrade cost in the next DEP rate case. Correct?
That's correct.
No further question.
All right, Mr. Josie, just reminding you, we'd like a late file exhibit of the communications with DEP referenced by Mr. Lucas in his testimony today.
We will
All
follow
right.
that as soon as possible.
Okay. All right. I believe we are at the end of these gentlemen's testimony. Just checking in, make sure I'm not missing something here.
Sorry, excuse me.
We're at the end of the testimony of these gentlemen. Am I missing anything here?
Just want to make sure that our panel has answered all the commission's questions from the September 2nd or September 6th.
Okay.
September order.
I'm checking back in the back corner to get a head nod or a shake. Okay. Commissioner Duffley, are you any additional questions for these gentlemen before we let them go? Okay.
No.
Okay. All right, gentlemen, y'all may step down. Thank you very much for your testimony today. All right.
Chair Mitchell, I think the witness presentations are done. If I may, to the extent that there are subsequent hearings scheduled in these dockets in EMP 111 and 110, we would request that they be canceled.
All right. We will address additional procedural issues such as the cancellation of hearings in subsequent order of the commission in each of the respective dockets, unless the public staff objects.
No objection.
Okay, and I'm not hearing objection from the public staff. All right. We will take proposed orders as soon as you want to get them in, subsequent to the notice of the transcripts availability. Yeah, for purposes of the record, just want to remind commissioners of our duty to avoid conflicts and inquire as to whether any member of the commission has a conflict with this matter coming before us. I'm seeing nothing, no conflict from Duffley, no conflict from Clodfelter. All right, so we are cleared from a conflict standpoint. All right, before we adjourn for the afternoon, anything else, public staff? All right. Snowden.
No, thanks. I just want to say thank you for expediting these proceedings. I know it's in everyone's mutual interest, but we've all got stuff to do, and I can go pick my daughter up from rowing practice.
We
now.
charge a lot less for expediting than apparently Duke.
Clearly, we need to develop a methodology here. All right. With that, then we'll be adjourned. Thank you very much, everybody, and we're off the record.
It's really good.